Under the legal microscope, there's a new focus on the doctrine of qualified immunity. A federal judge in Jackson recently questioned whether the principle is constitutional.
That has been abused and has been made more and more onerous by court decisions over time, from the Supreme Court down to the Fifth Circuit.
Qualified immunity was created by the U.S. Supreme Court nearly 60 years ago. It shields police officers from civil accountability if they're accused of wrongdoing on the job.
The people that support qualified immunity are concerned about frivolous lawsuits, the burden on the taxpayers for having to defend lawsuits.
U.S. District Court Judge Carlton Reeves issued the potentially monumental ruling just 2 months ago. The 62-page opinion laid out Reeves' legal analysis for denying qualified immunity to Jackson Police Detective Jacqueline Thomas. Desmond Green filed a civil lawsuit against Thomas. He claims he was wrongly arrested and charged with capital murder for killing a man. The suit accuses Detective Thomas of using a, quote, lying, drug-impaired jailhouse informant to lock Green up. The detective steered the informant to pick Green's face from a photo lineup, according to the judge. Reeves says that was, quote, horrifyingly wrong. The informant later recanted. Green was freed only after he spent nearly 2 years in the Raymond Detention Center. In denying Thomas' motion to dismiss the case, Judge Reeves wrote qualified immunity is an unconstitutional error. He says it's past time for the judicial system to correct this mistake.
It's a judicial creation, and there's certainly good arguments for rolling it back or abolishing it.
Attorney Michael Corey defends police officers accused of crimes like Anthony Fox. The Clinton police officer was freed from prison this year after a state appeals court overturned his conviction in the killing of George Robinson. Judge Reeves granted Fox immunity, and throughout a federal lawsuit Robinson's family filed against Fox.
I certainly believe Judge Reeves got that right, because at the end of the day, the medical evidence in the Anthony Fox case was clear that there was no beating, that the things in the indictment, did not happen.
Reeves said it should be up to juries and not judges to decide if accused officers committed bad acts.
If you are beating someone who's handcuffed, that is a violation of their civil rights. There shouldn't have to be case law that says that.
Attorney Trent Walker represents Rankin County Goon Squad victims Michael Jenkins and Eddie Parker. They filed a $400 million lawsuit against the 6 convicted officers and Sheriff Brian Bailey.
Part of what we've raised is a claim that his actions as sheriff, that he knew and turned a blind eye to, or else consciously was deliberately indifferent as to the actions of the members of his department.
Ironically, qualified immunity grew out of a racially charged 1967 case in Mississippi. A group of black and white ministers were protesting the state's Jim Crow system. They claimed their rights were violated when 3 white Jackson police officers arrested them as they tried to enter the segregated downtown bus station.
There was a white mob that was trying to get to them, so when the police arrived, rather than arrest members of the mob, or rather than dispersing the mob, they came and arrested the protesters who were protesting peacefully.
The ministers filed suit. The Supreme Court denied the ministers' relief based on the 1871 Ku Klux Klan law, commonly referred to as 1983. The purpose of that law was to protect newly freed African Americans from Klansmen with badges and government officials denying their rights.
Everybody just needs to look at what is the right balance to enable police officers to do their jobs, but also protect the citizens.
Corey, the lawyer who defends accused officers, believes qualified immunity goes too far.
Is it allows a defendant, a police officer sued for violating the constitutional rights of a citizen of the United States, to immediately file a motion to dismiss, stop all discovery.
Both Corey and Walker believe Judge Reeves wrote his opinion to force justices on the nation's high court to take another serious look at this controversial legal principle.
I happen to be one who believes that Judge Reeves's opinion is so factually correct and historically correct that it ought to be adopted in toto by the Fifth Circuit and or the United States Supreme Court, and that the doctrine of qualified immunity ought to be done away with.
In Jackson, Ross Adams, 16 WAPT News.